Health inspections are ongoing in the island's public schools, but today a pause in the lawsuit filed against the Guam Department of Education. The lawsuit contends GDOE leaders and Guam Education Board members failed to provide a safe place for their students to learn. Certain issues arising during a hearing held inside Superior Court Judge Elise Iriarty's courtroom, causing the delay. One specifically comes after Attorney General Doug Moylan told the court he plans to withdraw from providing legal representation. Though tasked to represent the Guam DOE, AG Moylan says his office has taken adverse positions on the Education Department and its officials. Moylan saying the named government officials in the lawsuit have not met the requirements of the Adequate Education Act and has indicated in their last hearing that it may intervene.
This is why it was difficult when the lawsuit was filed. The Attorney General is supposed to protect the public interest, and I believe that's recognized overall in most of the cases. Judge Manabusan in 2005 recognized that in his Babalta decision, that the Attorney General wasn't just elected to be the mouthpiece for any government official within the government. The Attorney General had a greater role in order to ensure that the public interest was protected. In this case, Your Honor, the public interest, in my opinion, is the legislature statute, which was to provide the Adequate Education Act. That's why there's a question on whether or not the Attorney General's office should be becoming a mouthpiece of the Department of Education and defending their positions, which they have merit here and there, or taking the bigger position that there has been a violation and that we cannot just be your mouthpiece as a board, a superintendent, or the Department of Education as an entity.
Additionally, Judge Iriarty noting a conflict with defense attorney Fred Nishihira, as he is employed at the AG's office and still representing the Education Department.
Based on this set of facts, the court is inclined to find that their withdrawal is proper and based on good cause. The court is inclined to find that the withdrawal will not incur significant delay, as DOE in-house counsel is prepared to take on the defense of the agency and its board members and superintendent.
AG Moylan also telling the court the Education Department and its officials can hire private attorneys to represent them. Meanwhile, Attorney Daniel Summerfleck, who represents the parents suing GDOE and its board members, wants the case to move forward.
As the court may be aware, there were parent-teacher conferences going on these last few days. My client went to her daughter's parent-teacher conference, and in the classroom where she has 4 classes, there was a 5-gallon bucket to catch the water coming from the ceiling. This is clearly an unsafe condition. It's clearly in violation of any standard of care, and we believe that presents a change in circumstances warranting the court to review the granting of the temporary injunction.
GDOE Superintendent Kenneth Swanson was also inside the courtroom. GEB Vice Chair Maria Gutierrez appeared virtually. Neither spoke during the hearings. Julianne Hernandez, KUAM News.